In this episode, we talk about how Rajasthan's coaching centre bill seeks to regulate the industry and why it is facing criticism. We also talk about one of the most intense unrest Nepal has seen in years over the government's sudden social media ban. But we begin today with the concern surrounding the Delhi High Court's recent decision to deny bail to Umar Khalid and 9 others in the Delhi riots case. Hi, I'm Ichha Sharma, and you're listening to 3 Things, the Indian Express news show. Last month, the Delhi High Court denied bail to the former JNU student leader Umar Khalid and 9 others in the Delhi riots case, more than 5 years after their arrest. Khalid, along with the others, including Sharjeel Imam and Kulfisha Fatima, have been charged as key conspirators of the 2020 Delhi riots, with the court saying that the riots were a premeditated, well-orchestrated conspiracy. These 10 individuals have been charged under the various provisions of the stringent Unlawful Activities Prevention Act, including Section 16, which prescribes the death penalty for committing a terrorist act. And what's striking here is that despite having spent more than 5 years in prison, their trial has still not begun. To understand the case against them and the concerns raised by the court's decision, my colleague Shashank Bhargava speaks to the Indian Express's national legal editor, Apurva Vishwanath.
Apurva, all these 10 people in this case have been accused of conspiring to have these riots, in which 53 people were killed and several others were injured. And the prosecution claims that, they are the linchpin. They are the chief conspirators. But tell us, what evidence does the prosecution actually have for that?
So there are 2 categories of cases in this Delhi riots trial that's going on in Delhi's Kadkardoma court. One set of cases, which are like literally hundreds of cases on the actual rioting and arson and, those cases. Those trials, many of them have concluded, and over almost 80% of them have ended in acquittals. Then there is this other big case, which is what the Delhi police says is a larger conspiracy case, that a group of individuals, in fact 18 of them, conspired to cause these riots. In that set of cases, about almost 10 accused were seeking bail, and the Delhi High Court denied bail to all of them. But what evidence does the state really have against them? And this is where this case is really unique in that sense, because much of this case is built around 2 aspects. One is this creation and participation of the accused in WhatsApp groups. And second is that there are so-called secret meetings that they held for days, planning for the riots, apparently. And the police has scores of witnesses, and these are protected witnesses, who were allegedly present in these secret meetings. So in a sense, these secret meetings are really public meetings because there were so many of them present there. What the accused say is that these were meetings. They're not even denying these because, some of them were even posted on social media, and some of them made speeches which were telecast on Facebook and Twitter and things like that. So these were meetings where a strategy was developed for protesting. When that protesting kind of extends to being insightful and becoming rioting, that is essentially what the police has to prove. And that's something that the courts have to really examine.
Okay, so you mentioned these secret meetings and participation in these WhatsApp groups. But is there no recovery in this case? For example, if any weapons were found at the residence of these people?
No, that's the interesting thing. For example, 2 of the accused in the batch who had been denied bail last week. For example, Umar Khalid was not in the city when the actual rioting happened. Sharjeel Imam was also not in the city when this happened. Yet they've been charged because what the state says is for a conspiratorial charge, you don't actually need to be present here. And there are all sorts of these very vague definitions and labels thrown around, which is that they are the intellectual architects of the riots and they are the masterminds. In fact, when you read Umar Khalid's, the charge sheet that the police brought against him, it starts with Umar Khalid, a veteran of sedition. So there are lots of these loosely thrown around words, which, may not mean anything in law. So essentially what the government has is this shadowy case that there was a conspiracy. and that this conspiracy is what led to the riots. But again, that who caused the riots, who incited the riots, those cases are falling apart in court. So it really is anybody's guess how the larger conspiracy case will also progress in a trial.
And you, of course, mentioned these witnesses who are under protection, and that's why they have names like Romeo and Pluto, for example. Can't they be questioned by the court at this stage? Because the prosecution is saying that they are relying on their statements to find out what happened in these secret meetings.
Yeah, so this is where, it gets really twisted because it's a circular argument. Because one, the state says, look, this is at the stage of bail. And for a bail, you can't go into a deeper analysis of the evidence because, that's the UAPA is structured like that. And the catch-22 is the trial is taking too long. So, if you want to do this in the trial, you can't because the trial hasn't even begun yet. But it's been 5 years and you continue to be in jail. So if whichever way you look at it, it's just a circular argument. In fact, the Delhi High Court very categorically says that they are not looking at a detailed analysis of the evidence. They are looking at quote unquote surface level analysis. And in the UAPA, and these are judgments that we've discussed before, there's a Supreme Court judgment called Zahoor Ahmad Shawatali. So that lays down the precedent that courts really need not go into the merits of evidence. And the problem is, Shashank, just to illustrate, I'll give you the example of one statement of a protected witness, right? It says that this protected witness, Pluto, went to deliver biryani in a Silampur house. So while he was delivering biryani in the basement, he apparently overheard a conspiracy to quote unquote burn Delhi down, right? And that they had secured funds and firearms or whatever for this purpose. And he testifies this. Now, has he seen any ammunition? Has he seen the funds being arranged? No. He says, I've overheard while I was delivering biryani, somebody talking about it. So what would happen in a cross-examination is you would ask, how long were you there? Who did you see? And there would be a test identification parade to see if he can actually identify any of the witnesses, bunch of these things. But in the absence of any of that, the court says, oh, Pluto has said this, which means they were conspiring. There's no way for you to really defend yourself in that situation. And that is essentially what this bail order does. The fundamental question is, when the state labels someone a terrorist, what is the minimum threshold of evidence that the state has to bring to the table? Or what is that minimum threshold that the courts have to ask before they allow prolonged incarceration?
Yeah, and in this regard, one statement that really stands out is the one that Solicitor General Tushar Mehta made. He said that, if you're doing something against the nation, you better be in jail till you are acquitted or convicted. Now, this seems like a very extreme statement because you're actually saying that it's okay for the process to be the punishment, and also presumes that those accused have done something against the nation.
It flies in the face of everything that we know about personal liberty and how the Constitution envisages the idea that someone is innocent until proven guilty, even in a terror case, right? So when the Solicitor General says, if you've done something against India, whose yardstick is that? Is that the state's yardstick, or should it be a judicial yardstick? And if you think of a judicial yardstick, what is the first basic judicial acknowledgement? And that is when the court frames charges against you, right? They say that you should be tried for XYZ offenses and you should be put on trial. Even that has not happened in this larger conspiracy case. A trial court has not even preliminarily made a case against any of the accused. So in the absence of that, that courts just simply take the state's version and keep someone in jail for 5 years. And when the court does not interrogate the state on why this case has been brought, essentially abdicating its responsibility. And that is what the real concern is about this bail case. Of course, it is the personal liberty of these individuals in the case, whether that's Umar Khalid or Gulfisha Fatima or any of these. But beyond that, it also brings into focus what the judiciary really ought to do in situations like this.
And also, Apurva, what is the reason that the trial has not begun yet? What is taking so long? And also, did the Delhi High Court acknowledge this delay?
One thing is about the delay in trial. The other thing is, the delay in even deciding these bail cases. And this is where it really kind of becomes perverse, because this batch of bail pleas, most of them were filed back in 2022. And it's taken 3 years for the High Court to even decide it. And that's not kind of accidental. It's not as if it was tariq pe tariq. It was like a willful disregard for the fact that these people are in jail. The first time it was heard before a bench, the bench reserved judgment, but for about 7 months just refused to deliver the judgment. So, and subsequently the judge was elevated as Chief Justice to a High Court and he just left. And these cases had to be heard all over again by a second bench. And even in the second round, the same thing happens. The judge is elevated and he's sent to Madhya Pradesh as a Chief Justice. And then the third time around, fresh arguments are made, and this is when the High Court delivers the verdict. So, in that sense, there is no acknowledgement of the court's fault here at all. Because, we are not just talking about judicial man hours, right? The fact that it's taken so much time in courts, but it's also like litigation costs. It's also the cost that they're paying through their liberty. The every day that the court doesn't pronounce judgment, it is eating into their lifetime. And the court doesn't even acknowledge any of these. In fact, there's a certain ridicule or contempt with which the court says that in a case like this, where the government has gone into such detail and done so much investigation, the trial will obviously progress in its natural pace. So it's completely unjustified, the delay, and because the court itself is responsible for it, it ought to have dealt with this issue more seriously.
And considering that the ruling is also saying that, it will only confine itself to a surface level analysis of the evidence, I was wondering what options do these accused have, or anyone accused in this manner have, to prove that they're actually not guilty? How does one even do that in a case like this?
I mean, that is the whole point of having your day in court, right? Like, you want to be able to convince the court that this is what happened. And if the court says at bail stage, we will not even go into any of the arguments, and at the same time delays it and the trial takes its own course, then what option does a citizen have but to end up just spending time in jail? Of course, now that the Delhi High Court has pronounced its verdict, whichever way, the accused will at least have a chance to appeal this before the Supreme Court. I mean, imagine this in 2022 when they filed their bail pleas. If it was decided, say, within 3 or 4 months or even a year, 2 years ago, they would have gone to the Supreme Court seeking bail. So you kind of ate into that time as well. So yeah, you have to wait for your day in court. And the issue is not so much that the court denied bail, but the issue is really that the court refused to engage with the credibility of the evidence. Even a basic appreciation of the evidence that the court said we are not going to do, which means we will completely take the state's version for what it is. That is the troubling part. If the court dealt with the evidence and in one way or the other said that they don't deserve bail, that's a judicial verdict and you're bound by it, and you go to a higher court and appeal, and if you don't get bail, you don't get bail. But the fact that even a prima facie analysis is kind of missing from the court's ruling, and it's a 133-page ruling with significant portions dedicated to each of the accused. And what you see over and over again is every inference that the state draws, right? For example, in the case of Gulfisha Fatima, there is a protected witness who says that the witness saw Tahir Hussain, the politician who's also an accused in the case, hand over cash to Gulfisha. And that is basically one of the acts that is part of the conspiracy. Now, this witness is not able to tell you how much money or what was the source of funding or whether, this was actually even real. So maybe in a trial, you would check where the witness was, how trustworthy the witness is for it to be considered evidence, right? But at this stage, without that opportunity, there is nothing that the accused can do about it. So in a sense, it is not that they didn't get bail. It is that the court didn't even engage with these things and simply accepted every inference that the state made on face value.
And Apurva, could you tell us what has the Supreme Court said in the past about granting bail in such cases?
Honestly, it's a very mixed legacy of the Supreme Court and grant of bail in anti-terror cases. It is not that the court has not granted bail. There are some very restrictive judgments when it comes to grant of bail, and the court has put strong limitations on the grant of bail. But one key exception to all of this is, the delay in trial. There are judgments of the Supreme Court, and in fact, it's been applied multiple times as a precedent that if there is a delay in trial, in fact, the court says that the most stringent of bail restrictions kind of melt away when there is a delay in trial, and that is eating into your liberty. In fact, this is this Najib case, which is from Kerala, and the court has applied this multiple times in many cases. So it's not as if that, there cannot be any ground for them to be granted bail. Even in UAPA cases, because the law says that the court has to be prima facie satisfied that the allegations are true. And what is that prima facie satisfaction is something for the court to determine for itself. So, that is the level of analysis that unfortunately in the UAPA has become what each individual judge does. There is no uniform yardstick. If a judge feels like they will look into some of the evidence, if another judge doesn't feel like, they will just go by the state's version and say our hands are tied because of the law. So that is the problem with the bail in UAPA.
And next, we turn our attention to Rajasthan, where a new law is taking aim at one of India's most influential education industries. Every year, thousands of students flock to Kota with dreams of cracking engineering and medical entrance exams. But the intense pressure of the system has also raised serious concerns. In fact, over the last 4 years, at least 88 students have died by suicide in Rajasthan's several coaching hubs. So against this backdrop, earlier this week, the Assembly passed the Coaching Centres Control and Regulation Bill 2025. Now, while this proposed law sets standards for registration, caps teaching hours, and calls for counselling and support systems, it has also drawn criticism for not going far enough to address the core issues. To understand what this law really changes and whether it can make a difference for students, we speak to the Indian Express's Hamza Khan in this segment. Hamza, could you outline for us the scale of the coaching industry in towns such as Kota and Sikar?
So there are multiple estimates about the scale of the coaching industry in Kota and Sikar and in fact all of Rajasthan. So if we talk about Rajasthan, then the MLAs in Rajasthan have claimed that the whole industry is about 60,000 crore rupees and there are like 10 lakh people employed directly and indirectly, which I think is an exaggeration because local estimates in Kota and Sikar have way different numbers. In Kota currently say that there are about 85,000 to 1 lakh students. And before COVID, the figure used to be like 2 to 2.5 lakh. But ever since COVID and the bad press over suicides, the number of students enrolling themselves in Kota has declined, which has come down to, like I said, around 85,000 to 1 lakh. And the annual revenue is estimated at rupees 3,500 crores to say 6.5 to 7,000 crores. And in Sikar, for example, a local MLA claimed recently in the assembly that 30 to 35% of Sikar's economy is dependent on coaching centers. And MLAs claim that overall across the state, there are about 50 lakh students who are enrolled in coaching centers in the state. But locally, like I said, there is one person, Rajesh Kulhari, who launched the Guru Kripa Coaching Center in Sikar. He, for example, estimates that Sikar's coaching economy is around 2,000 crore and Kota's is around rupees 6,000 crore.
And we know that the towns have had coaching hubs for years now. So why did the government feel the need to pass this bill now?
So there was a lot of public pressure over the bill, and even 10 years ago, there were PILs in the High Court on suicides in coaching centers in Kota. So the Rajasthan High Court had taken suo motu cognizance of student suicides in 2016, when it had said that in the past 5 years, about 78 students have committed suicide and no one has been held accountable. The High Court had said on January 4, 2016. And over the years, the case was going on in the High Court and it commissioned a study into student stress by Tata Institute of Social Sciences, issued guidelines, set up a committee and pushed for the formulation of legislation. And in its report submitted in March 2025, the Department-related Parliamentary Standing Committee on Education, Women, Children, Youth and Sports noted the lack of a regulatory framework at the national level to regulate the proliferating coaching center industry and the widespread reports of financial fraud in these coaching centers, as well as instances of student suicide, drug abuse, and mental health struggles. So over the years, the case was going on in the High Court and it kept on, like the previous government was led by Ashok Gehlot. And the High Court also pulled up the Ashok Gehlot government over dragging its feet on bringing about a legislation. But then it was a contentious issue because, bringing a law also risks alienating the coaching centers, they are said to have deep pockets. But finally, the Bachanlal Sharma government had to bite the bullet, and they finally brought about this legislation. And they initially brought a bill earlier this year, but then there was intense opposition to the bill, and it was sent to the select committee, and now the government has brought another bill with just minor changes. Yeah.
Right, and speaking about the bill, could you talk about what are its key provisions? And also, exactly how are they expected to change the way coaching centers operate?
So the proposed law will be enforced by a Rajasthan Coaching Centers Control and Regulation Authority, which will have senior officials, senior bureaucrats from all the different education departments, higher, technical, medical education, school education, etc., as well as the DGP, a psychiatrist, and representatives of coaching centers and parents' bodies. Then the state level authority will push on and implement its mandate through the district level authorities. So similarly, the district level committees will have a district magistrate, superintendent of police, chief medical and health officer, etc., apart from, again, representatives of coaching centers and parents' bodies. And the district authority will ensure the registration of coaching centers and their compliance with the law and setting up of grievance redressal cells. And the committee will also oversee various aspects of the functioning of the coaching centers, including the way in which fees are charged. And for example, the centers cannot charge the entire fee in one go. Like, they have been asked to break it into 4 equal installments spread over the duration of the entire course. They can't charge it in one go. And there is also provision which says that if a student wants to withdraw midway, then his fee has to be returned. So there are provisions like that. And the district committee will also see how complaints are dealt with and teaching is carried out. And the coaching centers will be required to apply for registration within 3 months of the act coming into force. And eligibility conditions include having a physical area of not less than 1 square meter per student, engaging tutors with at least a graduate degree, and not making misleading promises or guarantee of rank or good marks. And there are some other key points as well, basically aimed at improving the mental health of students, which include that the coaching centers must now have a system of counseling, a website with updated details, including the qualification of tutors, hostel facilities, policy on fees, and data on success rates. And also, students and teachers must have weekly days off, and coaching centers must not exceed 5 hours in a day, as in for one single student. And violation of the provisions of the law will attract a fine of rupees 50,000 in the first instance on the coaching center. A second violation will attract a penalty of rupees 2 lakh, and subsequent violation can lead to a cancellation of registration. In earlier version of the bill that I was telling you about, the penalties for the first and second violations were rupees 2 lakh and 5 lakh. And the third change, which is there in the present bill as compared to the previous version, is that earlier the law was applicable on centers with 50 students, but now it's applicable only on those centers which have 100 students or more.
Right, and Hamza, as you mentioned earlier, that the coaching economy is massive and so many locals are actually dependent on it. So how will this bill affect the business side of things?
So like the MLAs pointed out in the assembly, the tighter rules on fee, refunds, advertising, infrastructure could increase operational complexity and cost. And small resource constrained centers may struggle, but larger organized ones may be able to adapt better to the new rules. And in Kota, since it has a heavy dependence on the coaching industry, there are concerns about job losses, vacancies in hostels, and reduced businesses for, other services. Especially, if some centers have shut down and students, don't want to relocate. And around the coaching centers, a local economy comes up, including bookstores, chai stalls, restaurants, takeaways, and hostels, PGs, even the auto drivers, rickshaw pullers, doctors, hospitals, etc. They mushroom around, like even in Jaipur or in other cities in Rajasthan. Wherever there's a coaching hub, you'll find all these places nearby. And lots of activity, and these stalls are open late into the night or sometimes, overnight. But then all of this will be affected once in case the coaching centers have to shut down because of the new regulations. But that also depends how strictly these regulations are enforced. And in Kota, for example, the government is said to be pursuing tourism development also as a diversification strategy to reduce reliance on coaching-based revenues and to basically avoid burdening the coaching centers. Like, there was a key issue about the inclusion of 16 years of age as the minimum criteria for enrolling students in coaching centers. But that was not included in this bill, despite even the BJP MLAs pointing out in the debate for the earlier version. So the reasoning behind that is that the MLAs say that if we impose that restriction that coaching centers in Rajasthan can only take students who are 16 years of age or above, the ones who are younger will simply go to other states and enroll themselves there. So they are saying unless there is a uniform law across the country which mandates that coaching centers can't, enroll students who are 16 or over, there's no point in including that provision in Rajasthan alone, because that will already burden the coaching industry.
Right, and apart from these, the opposition leaders and even some ruling MLAs argue that the bill fails to adequately address some of the main issues, such as suicides itself. So talk a bit about that.
So in the assembly, in the debate for the previous version of the bill and in the current version, MLAs kept pointing out that, it talks about issues surrounding the suicide, but doesn't directly or adequately address the student suicides. They're saying that, there's a law to regulate coaching centers, etc., and, impose penalties on them. But then they were hoping for something more direct when it comes to dealing with student suicides. And they're saying that, one of the arguments is also that the government didn't consult with the opposition or the coaching centers or students or parents. And second, for example, the criticism of the bill is that, again, like I said, it dropped the minimum age limit of 16, which was given by the center in its guidelines, which were issued in January last year. And there were some other directions by the center which have been skipped in the state bill. And another argument which we have been hearing constantly from opposition MLAs, and we heard it in the debate earlier as well, was that it's bureaucrat heavy, like the committees at the district level and the state level committee. They are all bureaucrat heavy and it will only lead to red tapeism. And the MLAs pointed out during the debate that the collector and the SP are already very busy. And even for the state committee, the officials which have been involved, which have been made part of the state level committee, they too are very occupied. So they're saying that they won't have time anyway, because a district collector is part of, dozens of committees and he won't be able to give as much time. And they were also demanding that the local MLAs and MPs should also be made part of the district committees so that they also can have a more direct role to play in ensuring the compliance by coaching centers of these rules. And another criticism is that there have been rules are uniform. There is no division when it comes to, say, coaching centers which have a strength of, say, 100 to 200 students. Like one MLA in the assembly said that there should have been a study on coaching centers and there should have been a division. There should have been some way to separate the coaching centers by their size. Because here you have a one-size-fits-all approach, which may not work on the ground. So they're saying that, the uniform rules should not be there. There should be a division by the size of the coaching center.
Right, and there are issues being flagged about provisions for the parents in the bill as well, right?
Yeah, there is no provision for counseling or engaging parents, because we keep hearing that, in the suicide notes, often it's said that the child apologizes to his or her parents, saying that, I'm sorry, I could not fulfill your expectations, etc. So the MLAs also say that there should have been a provision to include and counsel the parents also, because it is at times parents who might unnecessarily or who might burden their child. So parental pressure contributes to the problem, but this has not been touched upon in the bill. And last, the MLAs also say that imposing these restrictions on the coaching centers might make them exit the state. They are saying that the quota industry is already in a pretty bad shape, and Seeker has come up in the last 2 decades, more or less, like a decade and a half. So they're saying that Seeker is not that big and quota is already in a bad shape. But if you push this law, then, it might push these coaching centers out of the state and, hurt the local economy even more.
In the end, we shift our focus to Nepal, where protests over government's sudden ban on social media platforms have spiraled into deadly unrest. Yesterday, Kathmandu witnessed its most intense protests in years. Thousands of young protesters clashed with police outside parliament after the government blocked more than 24 social media platforms, including Facebook, Instagram, WhatsApp, and X. Officials said these companies failed to register with Nepali regulators or appoint grievance officers and accused them of fueling hate speech, misinformation, and fraud.
युवा हाम्रो शक्ति हो बुढा नेता हात्ती हो नेताको छोरा गाडीमा गरिब जाति खाडीमा छातीमा गोली खाएको छु छातीमा यहाँ पनि गोली खाएको छु मेरो चस्मा फुट्यो आगे देश मैले प्रपर डकुमेन्टेसन बनाएको छु यो मेरो रगत हो नेपालीको रगत हो
What began at Kathmandu's Metigar Mandal quickly spread to cities like Pokhara, Biratnagar and Bharatpur. By the end of day yesterday, at least 14 people were killed. Dozens more injured and curfews were imposed as the army patrolled the streets. The protests were striking not only for their scale, but also for who led them. Most demonstrators were school and college students, part of Nepal's Gen-Z, largest demographic group in the country, and also its heaviest social media users. They carried national flags and chanted slogans such as "Stop the ban on social media" and "Stop corruption, not social media." Organizers even asked political parties to keep away, framing this as a youth-led movement. Meanwhile, Prime Minister K.P. Sharma Oli's administration defended the ban, saying platforms could resume operations once they complied with the law. But some critics argue the move is really about policing self-expression and muzzling criticism. The ban has also hit businesses in tourism sector that depend on online reach, while families say staying in touch with relatives abroad has become harder overnight. It is also key to note that this eruption of anger also reflects broader frustrations. For years, young Nepalis have complained about stagnant economy, rampant corruption, and the dominance of the same 70-plus leaders who they say have rotated in and out of power since 2008. Many in the country have already left the country in search of jobs, while those who stay see social media as both an outlet and a tool for accountability. Now, among those voicing support for the demonstrators is Kathmandu's mayor, Balendra Shah, a rapper turned politician whose own rise was fueled by online platforms. His backing highlights just how deeply this ban cuts into the political sphere as well. For now, Nepal's streets remain tense, and only time will tell whether these deadly clashes mark the beginning of a deeper confrontation with the country's aging political establishment. You were listening to Three Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar and produced by Shashank, Bhargava and me, Ichha Sharma. If you like the show, do subscribe to us wherever you get your podcast. You can also recommend it to someone you think may like it, with a friend or in your family. This is the best way for people to get to know about us. You can also tweet us at Express Podcast or write to us at podcast@indianexpress.com.